And that's a go.
We're live, waiting for people to join. All right, welcome everybody. We got the state's response to Kathleen Zellner.
Okay.
Going live with a live reading?
Yeah. There may be a time someone else is going to jump in here, but let's get going. State of Wisconsin, Court of Appeals, District. I don't read Roman numerals.
You don't have to read the case number either. Just.
All right. On appeal from orders denying multiple motions for post-conviction relief entered in Manitowoc County Circuit Court, the Honorable Angela W. Suckowitz. Suckowitz, whatever. Yeah, presiding. Brief of plaintiff respondent. Joshua Call is the Attorney General. Lisa Comfort is the Assistant Attorney General in this case. Then we go through our table of contents.
Issues presented. Statement on oral argument. Introduction. Statement of facts. Fundamental principles of post-conviction review. Criminal defense are required to raise all post-conviction claims at the same time, absent a sufficient reason for failing to do so. B, to warrant a hearing, motions must contain sufficient material facts that would warrant a relief and true, and record cannot conceivably demonstrate otherwise. Standard of review. Number 7, argument. Circuit Court properly denied Avery's June 7th, 2017 motion without holding an evidentiary hearing, which is fact. Avery failed to show his sufficient reason for failing to raise his June 17 claims in his February 2003 motion in direct appeal, so they are procedurally barred. Avery's conclusory allegation that he did not raise the claims in his 2013 motion because he is indigent and has no legal training was not a sufficient reason. After Avery has not shown this motion was sufficient plea. 3. Avery's allegation that post-conviction counsels were ineffective was insufficiently pled and meritless. A, law governing ineffective assistance counsel. Avery did not show the post-conviction counsels were ineffective. Law governing ineffective assistance of post-conviction counsel as sufficient reason. Avery's allegations about post-conviction counsels were conclusory and meritless. Avery claims that Zipper CD, renounced allegation conversation, and flyover video were insufficiently pled. Avery claims about the ineffective assistance of trial counsel were insufficiently pled and conclusively refuted by the record. Several Avery's claims about trial counsel are misframed, inappropriately raised, or not argued in his brief. Avery's remaining ineffective assistance of trial counsel claims did not warrant a hearing. Avery failed to sufficiently plead that Hagelpine and Askins were ineffective for failing to raise his new ineffective assistance of trial counsel claims. The Circuit Court properly exercised discretion in denying without a hearing Avery's claims related to the 2016 and 2017 scientific testing, legal standard and standard review for newly discovered evidence claims. The Circuit Court properly rejected Avery's claims related to the DNA testing. Avery arguments do not persuade. Nothing required the Circuit Court to allow Avery to pursue his claims piecemeal, so it appropriately denied October 6, 2017 motion for relief from judgment. The Circuit Court reasonably explained its decision denying Avery's motion to vacate judgment. Avery inappropriately argues for the first time on appeal that the court refusal to vacate its judgment violated 2007 preservation and testing order. Nevertheless, the claim is meritless. Avery forfeited his argument with the 2007 preservation order, allowed him to pursue his claims piecemeal. The 2007 preservation order does not give Avery a license to pursue available claims piecemeal. The circuit court properly exercised its discretion with denied the claims raised in Avery's motion for reconsideration as procedurally barred. Legal standards and standard review for motions for reconsideration. The circuit court appropriately exercised the discretion of denying Avery's motion for reconsideration. The circuit courts properly found the claims raised in Avery's motion for reconsideration were procedurally barred. Avery officially pled his Brady claims about Heidel and Ramlo, which are nevertheless meritless. The circuit court properly exercised its discretion when it denied without a hearing Avery's July 18th, 2018 motion regarding Detective Veely's compilation of the items copied from the Dassey computer. The circuit court properly exercised its discretion in denying Avery's March 2019 motion without a hearing. Avery's claim is procedurally barred because he has not established a sufficient reason for not bringing his claims to any of his prior post-conviction motions. If the court chooses not to apply the procedural bar, Avery's claim is not cognizable in the collateral review. Even if Youngblood applied to the post-conviction destruction of evidence, which it does not, Avery has not met his pleading burden. Court lacks jurisdiction to review Avery's motion to comply discovery, and then the conclusion. No, we'll skip all this table of authority bullshit.
Issues presented. Did the circuit court erroneously exercise its discretion in denying Stephen Avery June 2017 Wisconsin state? I guess that's statute. The state has recognized and restated the issues to clearly address the only question before the court, whether the circuit court erroneously exercised its discretion when it denied each of Avery's, I got to put my glasses on, I'm sorry, 5 separate motions without a hearing. Avery has presented his claims to the court as if he presented all of his arguments of the circuit court at the same time, and as if the circuit court rejected them all on the merits. That is not what happened. Avery filed his second Section 974.06 motion in June 2017, and the circuit court denied it without a hearing on October 3rd, 2017. Avery then filed a motion to vacate judgment on October 17th, 2017, seeking to vacate the court's order so he could amend his June 2017 motion. Before the court ruled on that motion, Avery filed a motion for reconsideration and 2 supplements to it, raising a host of new arguments. The circuit court denied Avery's motion to vacate judgment and motion for reconsideration in a single order, finding no cause to vacate its judgment and finding the new claims and arguments raised in the judgment or in Avery's motion for reconsideration procedurally barred. Avery filed another motion on July 6, 2018, alleging a Brady violation about the state's examination of Dassey's computer, and another on March 11, 2019, alleging a Youngblood violation. These were denied without hearings on September 6, 2018 and August 8, 2019, respectively. Accordingly, whether the circuit court erroneously exercised its discretion each time when it denied the respective motion in front of it is the only question properly before this court. That question cannot be coherently addressed in the way Avery has organized his brief, with arguments that were raised in different motions and that were denied on different grounds lumped together topically. Further, to the extent that Avery has addressed his separate motions separately, he has done so non-chronologically. The state has therefore reorganized the issues. The Wisconsin Supreme Court abandoned the term abuse of discretion in favor of erroneous exercise of discretion over 2 decades ago. City of Brookfield versus Milwaukee Metropolitan Sewerage District, 171 Wisconsin, and the rest of the numbers there. The motion, it's 974.06 motion, which has his second section 974.06 motion without holding an evidential hearing. The circuit court concluded that Avery's motion was insufficiently pled and that he did not show a sufficient reason for failing to raise these claims on direct appeal or in his first section 974.06 motion. It further concluded that none of the Avery's allegedly newly discovered evidence raised in a reasonable probability of a different result at a new trial if admitted. This court should affirm the circuit court. 2, was the circuit court required to allow Avery to pursue his section 9.4.06 motion piecemeal for any of the following reasons? 1, because the parties had reached an agreement about how Avery would proceed with scientific testing. 2, because Avery planned to supplement his motion, but did not alert or seek approval to do so from the court. Or 3, because the circuit court's 2007 preservation order. The circuit court was presented only with the first 2 of these arguments and noted that Avery never requested that the court withhold decision on his section 974.06 motion, nor informed the court that he planned to supplement the motion until after a final ruling denying his claims. It determined that Avery could not amend a motion that was filed without reservation, quote, after he receives an adverse ruling. This court should affirm the circuit court. 3, did the circuit court erroneously exercise its discretion when it denied Avery's motion for reconsideration and multiple supplements to it without holding an evidentiary hearing? The circuit court noted that Avery mischaracterized as, quote, new evidence, unquote, what were really new claims, and he did not set forth a sufficient reason why these many claims could not have been raised in a single section 9.7406 motion, nor did he give a sufficient reason for filing his June 2017 motion when he knew his investigation was incomplete and that he planned to raise additional claims. It denied the claims raised in the motion and supplements as procedurally barred. The court should affirm the circuit court. 4, did the circuit court erroneously exercise the discretion in denying without a hearing Avery's motion alleging that the state violated Brady versus Maryland by failing to supply the defense with the CD-contained material? Detective Michael, is it Velli?
Veely.
Yes. Copied
Veely.
from the DASI hard drive and Avery's attendant ineffective assistance of counsel claim. The circuit court offered that the state turned over all the evidence to the defense, and the defense simply failed to assign it any significance and pursue it. It further determined that Avery's ineffective assistance claim was conclusory and undeveloped. This court should affirm the circuit court. Number 5, Did the circuit court erroneously exercise the discretion of denying without a hearing Avery's motion alleging that the state violated Wisconsin statute 9.8 or 968.205 and Arizona versus Youngblood by releasing portions of the bone fragments collected in the case to the victim's family? The circuit court found that though the state failed to abide by the notice provision contained in the statute, it had not violated the substantive subsections, and that the material returned was neither apparently nor potentially exculpatory. Accordingly, Avery failed to allege sufficient facts showing that the state violated statute or his constitutional rights. This court should affirm the circuit court. 6. Does the court lack jurisdiction to review Avery's motion to compel post-conviction discovery? The circuit court never ruled on this motion. Avery forfeited any complaints about this motion by failing to ask the circuit court to rule to it before filing his appellate brief, which this court lacks jurisdiction to review in any event because this is no written order denying it. There is no written order denying it. Statement of oral argument and publication. The state does not believe that the oral argument of publication is warranted. The case involves only the application of well-settled law on the procedural bar and post-conviction pleading standard to the facts, which can be adequately addressed on briefs. Introduction. Avery has embarked upon a significantly different venture than this appeal presents. He seems to erroneously believe that he is appealing the jury's determination of guilt. He further seems to believe, also erroneously, that if he can identify any conceivable alternative theory to the crime, he has disproven the state's case against him and proven the existence of the constitutional violations he alleged. No matter how insignificantly supported, speculative, inconsistent, far-fetched, or belatedly raised his argument is. Accordingly to the bulk of his brief is dictated to the relitigation, his trial defense, though he cannot seem to settle on any particular theory. But as he did in the circuit court, Avery has all but ignored the actual issue in the heart of the appeal, the procedural posture of his case. This case is before this court on an appeal of the circuit court's orders denying without hearing Avery's 2nd through 6th motions attempting to collaterally attack his conviction. These motions were denied without hearings to the grounds that they were procedurally barred, insufficiently pled, or the record conclusively demonstrated Avery was due no relief. According to the question on appeal, it is not whether Avery is guilty of killing Teresa Halbach. That question has, for the jury, which many years ago answered yes, beyond a reasonable doubt, nor is the question on appeal whether Avery's latest counsel can construct a different trial defense, find new ways to attack the trial evidence, or identify issues that have not been raised previously. The only question before the court is this appeal is whether any of Avery's motions entitled him to an evidentiary hearing. The answer to that question is no. Though Avery has made a litany of allegations across the many motions, three critical things were absent from his forest of paper, sufficient reason for failing to raise all his post-conviction claims at the same time. Sufficient material facts of record to support his allegations, and any developed argument applying to the law to explain why the facts of record led to the legal conclusions Avery claimed. It is too well settled for argument that the circuit court has discretion to deny insufficient motions such as Avery's without a hearing. Avery has now glossed over his piecemeal litigation, the deficiencies in his motions, by simply re-arguing the merits of his claims in his appellate brief, without any reference to how or when he presented them to the circuit court. But on the review of the circuit court's decision to deny the post-conviction motion without a hearing, this court looks only to the significance of the allegations contained in the four corners of the motion filed in the circuit court. And Avery has fallen far short of showing that any of his motions were significant to entitle him to a hearing. Indeed, he has almost entirely failed to address the issue despite being his burden and the only issue on appeal. The circuit court appropriately exercised its discretion to deny Avery's motion without a hearing, and Avery has failed to show otherwise. This court should affirm the circuit court. Statements of fact. Pursuant to Wisconsin Rule 809.19, 3A2, as respondent, the state opts to omit the statement of the facts. Pertinent facts will be provided in the argument section. Fundamental principles of post-conviction review. A, criminal defendants are required to raise all post-conviction claims at the same time, absent a sufficient reason for failing to do so. Quote, we need finality in our litigation, unquote. State versus Evescalon Navajo. Yeah, that's it. 185 Wisconsin, 2D, 168, 185, 517, Northwest, all that stuff. Accordingly, after the time for the direct appeal has passed, a defendant's ability to attack a conviction or a sentence is limited. Jurisdictional or constitutional challenges to a conviction or a sentence may be brought pursuant to Wisconsin Statute 974.06(1), but Wisconsin Statute 974.06(4) bars successive post-conviction litigation absent a, quote, sufficient reason, unquote, for not raising the issue advanced in a later post-conviction motion on direct appeal or in an earlier motion. State versus Lowe, 2004, Wisconsin 107, 17 through 20, 24, Wisconsin 2D 1665, NW 2D 756. Successive and often reformative claims clog the court system and waste the judicial resources. State access, that's another case that's stated. Yep. Maceman versus Christie. Thus, the statutory mandated review process under 974.064 requires that all of the defendant's claims post-conviction relief be, quote, consolidated into one motion or appeal, unquote. In other words, convicted defendants are not entitled to pursue the endless succession of post-conviction remedies, quote, successive motions and appeals, which all could have been brought at the same time and run counter to the design and purpose of litigation, end quote. Escalona, Navarro, 185, Wisconsin 2D at 185. B, to warrant a hearing, motions must contain sufficient material facts that would warrant relief, if true, and the record cannot conclusively demonstrate otherwise. Quote, to move beyond the initial prerequisites of Wisconsin Statute 974.064, Escalano Navarro, and to adequately raise the claim for relief, a defendant must allege, quote, sufficient material facts. Example, who, what, where, when, why, and how, that if true would entitle the defendant to a relief he seeks, unquote. State versus Romero, Georgiana, 2014, and the statute is listed there. Conclusory statements that do not contain these key facts are insignificant to entitle the defendant to a hearing. John Allen, 274, Wisconsin 2D, 56812. The significance of the allegations in the motion, however, is not the end of the inquiry. Quote, a circuit court has the discretion to deny the defendant's motion, even for properly pled motion, without holding an evidentiary hearing if the record conclusively demonstrates that the defendant is not entitled to relief. State versus Sully, 2016, Wisconsin 4630369, Wisconsin 2D 22580, NW 2D 649. Standard of review. Quote, the court will upload the circuit court's findings to fact unless they are clearly erroneous. State versus Thiel, 2003, and the statute is listed. The circuit court's factual findings are clearly erroneous only if they have no support in record. Schreiber versus Physicians Insurance Company of Wisconsin, and in the case is listed there. Whether claims are barred by Wisconsin Statute 974.064 and Escalona Navarro is in question of law, this court reviews de novo, state versus toll-free, and the statute's listed there. Likewise, whether a defendant's post-conviction motion on its face alleges facts which would entitle the defendant to relief, and whether the record conclusively demonstrates that the defendant is entitled to no relief, are questions of law that the appellate court reviews de novo. Sulla 369, Wisconsin 2D 22-5-23, citation omitted. This court reviews, quote, only the allegations contained in the four corners of the defendant's motion and not any additional allegations that are contained in the defendant's brief. John Allen, 274, Wisconsin 2D 56827. If the defendant's motion fails to adequately allege a significant reason to overcome Escalano Navarro, does not contain a requisite material facts, quote, presents only conclusory allegations, or if the record conclusively demonstrates that the defendant is not entitled to relief, unquote, then the court reviews the circuit court's decision to grant and deny a hearing, quote, order of differential erroneous exercise of discretion standard, end quote. And then it has another citing of State versus Belletti. A court exercises discretion when a court considers the facts of record and reasons its way to rational, legally sound conclusion. State versus Jessic. The court The quote, the court's discretionary determinations are not tested by some subjective standard or even by this court's own sense that might be right or wrong decision in the case, but rather will stand unless it can be said that no reasonable judge acting in the same facts and underlying law could reach the same conclusion. Additionally, it's well established that if the trial court reaches the proper result for the wrong reason, it will be affirmed. State versus Holt. Supersede by statute on other grounds. Millbilly, you want to take on for a little bit?
Sure.
Under
Argument.
argument.
The Circuit Court properly denied Avery's June 7th, 2017 motion without holding an evidentiary hearing. Allegation Avery's June 2017 motion. As relevant here, Avery raised the following claims in his June 2017 on the 27th, Section 97406 motion. Avery's trial attorneys, Dean Strang and Jerome Buting, were ineffective for failing to obtain 6 additional expert witnesses in blood splatter patterns, trace evidence examination, forensic anthropology, burned remains, DNA testing, and police procedure. Trial counsels were ineffective for failing to conduct various experiments. That only one person, Riley Hilgis, meets the requirements of Denny as a third-party suspect. Avery raised several claims in each of his motions that he has not pursued an appeal. By failing to brief those issues, Avery has abandoned them, and the state will not discuss them further. A.O. Smith Corporation versus Allstate Insurance. Avery relied on the experts in his motion, but either never made an argument that Strang and Buting were ineffective for failing to hire them, or has failed to pursue the argument on appeal. Trial defense counsel failed to properly investigate a variety of topics about several evidentiary items. The state withheld, in a violation of Brady, Maryland versus U.S., a CD of voicemail Teresa Halbach left on the zipper of the family's answering machine the day of her murder, stating that Ms. Halbach was having trouble finding her house. Unedited flyover video from an air search on the neighbor's property and investigators' purported knowledge that Teresa Halbach's Toyota RAV4 was driven onto Joshua Redon's property because Redon provided an affidavit stating that some unknown person from the Department of Justice told them they believed the RAV4 was driven onto the Avery property. I believe that person is Fassbender because he's the one that chimes in during Stephen Avery's interview on the 9th and says, we know how the car got there. Side note. That Avery had newly discovered evidence established that one of the damaged bullets introduced at trial, item FL, was not shot through the victim's skull. 2, Avery's DNA on the RAV4's hood latch was planted. And 3, Avery's DNA on the key to the RAV4 was planted too. Avery alleges that this is sufficient reason for failing to raise these claims on direct appeal was ineffective assistance of post-conviction counsel. Avery further alleged that the sufficient reason for failing to raise all these claims in his 2013 Pro Section 97406 motion was that he had no way of knowing about his claims because he was a learning disabled indigent prisoner. The Circuit Court's order denying the motion. On October 3rd, 2017, the Circuit Court denied the motion without an evidentiary hearing. 628, the court determined. Avery had not shown a sufficient reason why these issues could not have been raised in his 2013 motion or other prior post-conviction litigation. It's further found that Avery's arguments stemming from his new experts' reports omitted several significant facts, showing that the results of the testing and now show what Avery claimed they did, and that he relied mainly on conclusory allegations. Accordingly, it found Avery had not met his burden to show that there was reasonable probability of the different results of a new trial where the results were admitted. 678:5-6. Avery failed to show sufficient reason for failing to raise his June 17, 2017 claims in his February 2013 motion or on direct appeal, so they procedurally barred. Avery's June 2017 Wisconsin Statute 974.06 motion was his third attempt at post-conviction relief. For the court to reach the merits of allegations, then Avery had to overcome Escalante twice. He had to adequately plead a sufficient reason for failing to raise his June 2017 claims in his Wisconsin statute motion and his 2013 section motion. Avery showed neither, so the circuit court properly exercised the discretion in denying his motion without bearing. Avery's conclusionary allegation that he did not raise these claims in 2013 motion based because he is indigent and has no legal training was not sufficient reason. Avery failed to properly plead a sufficient reason for not raising his 2017 claims in his 2013 motion, and therefore this court can go no further to determine that the circuit court properly denied the 2017 motion without a hearing. Avery devoted a mere 2 paragraphs of his 200-plus page motion to alleging a reason for failing to raise his claims in 2013 motion. The sole reason for Avery offered in his conclusionary statement is that he had lack of legal knowledge and unspecified cognitive deficiencies, and claimed that he therefore had no way of knowing the factual and legal basis that claims set forth herein. As a learning disabled indigent person, Mr. Avery simply could not have known them. Only facts he supplied about his claim were that the current attorney had spent a lot of time and money preparing the motion. Avery's allegation was factually and legally insufficient. First, assuming the cognitive difficulties and a lack of factual and legal knowledge could have been sufficient reason, Avery failed to allege sufficient material facts to support his allegation or assertion. To be sufficient, defendant's reason for failing to raise claims previously must be supported by more than conclusory allegations. Avery's claim that the numerous unique circumstances are presented here provide sufficient reasons for current claims were not previously presented, but he did not attempt to explain what those circumstances are. He did not explain why the circumstances are unique, why or how they precluded Avery from knowing about his claims. What legal or factual knowledge was required, Avery lacked, particularly in the light of his many pro se filings, setting forth relevant law and discussing his case. What Avery's cognitive deficiencies are, or how they prevented him from knowing about the raising his claims or current counsel decision to spend vast sums of money meant that Avery was unaware of his claims previously. Avery claimed that he had no way to know the factual basis for his claims was practically insufficient. It amounted to a bare-raising mention of term factual basis. In other words, Avery provided no facts that allowed the reviewing court to immediately assess his reason. State versus Bentley and State versus Saunders. The circuit court was well within its discriminatory authority to deny the motion without hearing for failing to overcome the procedural bar. Avery's allegation was insufficient for a second reason, while lack of knowledge of the factual basis for a claim may be sufficient reason. It has long been recognized that the defendant. Yeah.
Your audio started cutting out really bad on the live. It went.
Take it back over.
So 1 second here. I think I can. If I was trying to see that. So where were you at? I think I can read some here for you while you maybe fix the audio. What was the last part you were at?
Avery's allegations was insufficient for a second reason.
Okay, I'll start there and I'll read for a little bit. Yours actually came back now. It seems to, but I'll take over for a little bit and give you guys a break. So, while a lack of knowledge of the factual basis for a claim may be sufficient reason, it has long been recognized that a defendant's pro se status or lack of legal knowledge is not. See State v. Jensen, 2004, Wisconsin, I'll leave out the statute. People can read that. Ignorance of the law is no defense. See also Jackson versus Bainan. No Wisconsin court has recognized ignorance of the law as a sufficient reason under 974.06 and collecting cases. Nearly all collateral attacks are raised by pro se prisoners, many of whom have intellectual challenges and very few of whom are lawyers. While Wisconsin state courts liberally construe pro se prisoners' filings, prisoners are still expected to properly raise claims for relief, including sufficiently overcome the procedural bar Romero Giorgiano. None of the cases Avery cited support his claim that the lack of legal knowledge, indigency, or pro se status is a sufficient reason. Avery misinterpreted or misread them all. In Aaron Allen, the court rejected the state's defendant's claim that his unawareness of the factual basis for his claims was a sufficient reason, because the record showed that the claims involved events in which Allen was personally involved and had personal knowledge that has nothing to do with the defendant's unawareness of legal basis of his claim. I'm not going to read any of the statute stuff.
Don't have to.
Okay, and Aaron Allen establishes the lack of knowledge. The factual basis for a claim does not mean what Avery appears to think it means. Lack of knowledge of the factual basis for a claim means an event occurred that supported a claim, and the defendant had no way of knowing about the event. See Aaron Allen. It does not mean that the defendant simply did not know what facts an attorney might use to argue the claim. Avery knew all about the facts in his case. Also, in Aaron Allen, the court rejected Avery's precise argument that State v. Howard established lack. Sorry, a lot. When you move there, I lost my place. Okay, you got to scroll up. Sorry. To the next section. There we go. A little bit down, sorry. You moved too fast for me on that one. It's that 815. Okay, in Aaron Allen, the court rejected the defendant's claim of his awareness of the factual basis for his claim was sufficient reason. Oh, wait, that's the same one.
Yeah, I know. I was moving to the next one.
Oh, okay. There we go. And Aaron Allen establishes the lack of knowledge of factual basis for the claim does not mean that Avery appears to think it means. Lack of knowledge of the factual basis for a claim means an event occurred that supported a claim, and the defendant had no way of knowing about the event. See Aaron Allen. It does not mean that the defendant simply did not know the facts an attorney might use to argue the claim. Also, in Aaron Allen, the court rejected Avery's precise argument. State v. Howard established the lack of legal sophistication as a sufficient reason. Aaron Allen, we'll skip that. Howard established that the lack of knowledge of the legal basis of the claim may be a sufficient reason where subsequent Supreme Court decision constituted a new rule of constitutional law. ID citation omitted. Like in Allen, Howard is an inopposite here. There is no question that Strickland v. Washington and Brady 373 U.S. 83 were established law at the time. Avery filed his 2013 section 974.06 motion. Aaron Allen 328 Wisconsin. Okay. So State Kiles versus Pollard does not stand for the proposition that lack of legal knowledge due to pro se status is a sufficient reason either. In Kiles, the defendant was denied counsel during a critical stage of the proceeding. The Supreme Court determined that his night, that reads weird, neither paragraph Avery cites for this proposition even arguably supports that statement. Paragraph 44 is the court's rejection of Allen's allegation that Howard supported his claim. See Aaron Allen, 2010, Wisconsin 89. Paragraph 81 is not a statement of any legal principle, but a quote from this court about whether Anders' procedure was followed in Allen's case.
So we'll go back. So it went from determined that his Knight petition was not procedurally barred by his previous attempts to reinstate his direct appeal. But there was because the court found in Cornelius the defendant was denied that the right to counsel and then precluded that the defendant from raising a claim because of the errors made due to the absence of counsel. There is no right to counsel on collateral attack. So Avery cannot plausibly argue Kyle's established that pro se status is a sufficient reason for failing to raise a claim in the earlier section 974.06 motion where he had no right to counsel. Neither this court nor Wisconsin Supreme Court has ever constructed Kyle's in manner Avery suggests. Avery has not shown his motion was sufficiently pled. Avery has failed to show that his June 2017 motion, two compulsory paragraphs about his 2013 pro se motion were sufficiently pled, or that the record does not conclusively refute them. Avery claims in his brief that he has met all of the Allen requirements for his claims, but he has misunderstood the pleading standard. Avery directs this court only to appropriately met those requirements in his appellate brief. To be entitled to a hearing, Avery had to meet those requirements in his motion to the circuit court. He cannot cure the deficiencies in his motion in his appellate brief. Avery complains that the circuit court did not analyze whether these collective circumstances constituted a. Avery has made this same error in regard to all of his claims, not just claims he raised in the 2017 motion. Sufficient reason, but he's made no showing that he pled sufficient facts for the court to analyze. The court noted that Avery claimed that his pro se motion should be precluded, his June 2017 motion, from being heard. But the court found there is no argument or showing of sufficient reason why these issues could not have been raised in prior motions. Avery simply stating he was incapable of raising the claims is not a factually supported argument claim explaining why not, and the circuit court was not required to develop it for him. Furthermore, Avery's assertion that he was incapably recognizing and raising legal claims was demonstrably false. The circuit court remarked that Avery's pro se motion recognizable significant legal issues which the court previously ruled on. These issues included ineffective assistance of child and post-conviction counsel. The fact that the court rejected those claims does not mean Avery was incapable of raising legal claims, as Avery appears to believe. Avery now attempts to bolster his motion by asserting that his reason is sufficient because he wrote to dozens of attorneys and wrote to laboratories that would not respond unless he had an attorney. Avery did not make these assertions in his June 2017 motion, and therefore they are irrelevant in evaluating whether the circuit court properly denied the motion it had before. Regardless, these allegations refute Avery's assertion. Obviously, if Avery, there's a footnote, Avery alleged that it is an affidavit, but exhibits do not relieve the defendant of alleging pertinent facts in the motion. So it goes from, obviously, if Avery contacted attorneys and laboratories in an attempt to raise these issues, he knew that they were available to be raised. Otherwise, Avery simply reiterates that he told the circuit court that he lacked his legal sophistication to raise the claims, quotes his own section 97406 motion as legal authority, and directs this court to do the same in opposite case. Law he cited below. None of the shows that sufficiently pledged his motion. In short, Avery's bare bones assertion in his 2017 June motion was not enough to allow the circuit court to meaningfully evaluate his alleged reason for failing to raise his June 2017 claims in his 2013 motion. So the court found that he had not shown a sufficient reason. That was a reasonable evaluation of Avery's motion, and he has failed to show otherwise. The circuit court properly exercised its discretion in denying Avery's June 2017 motion without hearing. Avery's allegation for post-conviction counsels were ineffective, was insufficiently pled, and meritless. Even if this court overlooks Avery's failure to show a sufficient reason for failing to raise his current claims in his 2013 motion, it should still affirm the circuit court. Avery failed to sufficiently show that either trial or post-conviction counsel were ineffective. Although the circuit court was wrong about the law on post-conviction procedure, the court shows that it still reached the right conclusion accordingly. This court must affirm its decision to deny the motion without a hearing. Law governing ineffective systems of counsel. Wisconsin criminal defendants are guaranteed the right to effective assistance of counsel through the 6th and 14th Amendments of the federal Constitution. To prevail under a Strickland, the defendant must prove his counsel performance without both deficient and procedurally. The defendant does not show the first element simply by demonstrating that his counsel was imperfect or less than. To prove deficient performance, a defendant must show specific acts of omissions of counsel that are outside the wide range of professionally competent assistance. Counsel's decisions based on reasonably sound strategy and virtually unchallengeable and do not constitute deficient performance. The defendant may not presume the second element, prejudice to this defense, simply because certain decisions of actions of counsel were made in error. To prove prejudice, the defendant must show that the counsel's deficient performance actually had an adverse effect on the defense. Strickland versus U.S. Further, the defendant must do more than show his counsel's errors has some considerable effect on the outcome of proceeding. The defendant must show that there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. B. Avery did not show that post-conviction counsels were ineffective. 1. Law governing ineffective assistance of post-conviction counsel as a sufficient reason. Avery claimed that it's sufficient reason for failing to raise a direct appeal in this ineffective assistance of trial counsel claims regarding hiring experts, performing experiments, and attempting to pin the crime on Ryan Hilgis, along with his Brady claims regarding the zipper voicemail, the flyover video, and Radonta allegations, was that the post-conviction counsel, Susan Hopang and Martha Askins, were ineffective. Ineffective assistance of post-conviction counsel may constitute a sufficient reason for failing to include claims in earlier motions. To overcome the procedural bar on the ground, though the defendant must allege sufficient facts that are supported. Another footnote. Avery had falsely represented that he raised his Brady claims regarding Denise Heidel and Kevin Ramelow and Detective Vili Cedi in his second motion pursuant to Wisconsin 97106, and implies that the circuit court denied them on October 3rd, 2017 in order. These claims were raised in Avery's October 23rd to November 2017 motion for reconsideration and his July 2018 section, and denied subsequent orders. The state addresses whether the circuit court properly rejected the claims in issue 3 and 5, and not address them here. By the record, and would show the post-conviction counsel's failure to raise a claim both deficient and procedural. If prejudicial, the defendant makes a mere conclusory allegation that post-conviction counsel was ineffective. His reason is not sufficient. Additionally, a defendant who alleges that 97406 motion is post-conviction counsel was ineffective for failing to bring certain viable claims must demonstrate the claims he wishes to bring clearly stronger the claims post-conviction counsel allegedly actually brought. This standard is difficult to meet because the comparative strength of two claims is usually debatable. Avery's allegations about post-conviction counsels were conclusory and meritless. The state does not dispute the civil court confused the procedure for raising ineffective systems of post-conviction counsel with the procedure for raising ineffective assistance of appellate counsel and rejecting this claim. However, whether a Section 9706 motion adequately pleads a sufficient reason for failing to bring available claims is a question of law, reviewed by Novo Romero Gorgano. This court will affirm its circuit court reached the right results for the wrong reason. And here, the record shows that the circuit court still properly denied Avery's motion. Avery's motion was conclusory because it failed to carefully address the two elements of inefficient system of post-conviction counsel set out in Strickland. And the motion generally ignored 5 WS on H methodology outlined in John Allen, Bailey, Wisconsin. Hagopane and Askins raised 4 issues on Avery's direct appeal. The court had improperly barred Avery's from admitting third-party proprietary evidence. Multiple searches had violated Avery's Fourth Amendment rights. The trial court had improperly excused a deliberating jury, and trial counsels were ineffective for to the dismissal. Avery stated the post-conviction counsels were ineffective because they failed to argue that Mr. Avery trial defense counsels were ineffective as described. In 2017 motion, he then claimed that the ineffective assistance of trial counsel was clearly stronger than the issues raised in there. Avery recited how the post-conviction court ruled on the third-party proprietary claim and reiterated his alternate theory of evidence constructed with his new experts' experiments. He then stated that Hepburn and Askins could have raised their ineffective assistance and Brady claims should have learned the alternative theory of events from Avery, and declared post-conviction counsel ineffective. Though Avery cited cases about ineffective assistance in the June 2000 motion, he failed to apply that law, and the facts explain how Hagopane's and Askins' failure to raise new claims objectively unreasonable, and that there was a reasonable probability of a different result if they had. His motion was insufficient in multiple fronts, and accordingly, Avery failed to overcome the procedural bar. Somebody else want to take over? No? All right. Avery's claims about the zipper.
I can if you want me to, Mobilly.
I use the bathroom.
All right. Avery's bald allegation of Hologian, I'm not even going to say those right. I butcher every name. And Askins should have raised the Brady claims of fiscally insufficient because it simply concludes that the failure to do so was deficient and prejudicial without providing any facts or developing any argument. John Allen, and there's the statute. Avery made no attempt to show why it was unreasonably not to raise these claims, provided no evaluation of the comparative strength of these claims to the claims post-conviction counsel raised, and made no attempt to show that there was a reasonable probability of a different result. The underlying claims were insufficiently pled as well. Avery's allegation that Redant supposedly spoke with some unidentified DOJ personnel fails to provide any material facts about this claim. Avery does not say who Redant had this conversation with, when it occurred, what the context was, what this person's, quote, belief, unquote, was based on, or why Redant did not tell the trial counsel or anyone else about it in the 12 years between trial and his affidavit. Further, Avery did not provide any facts to establish that it would be material. he said only that this quote information could have been used to impeach the state's witness, end quote. With nothing about, I just moved my page. With nothing about who it would have impeached or why, that would have raised a reasonable probability of a different result at trial, considering the rest of the evidence. Avery further claimed Raddat's testimony would have provided exculpatory evidence that the RAV4 was planted on his property, but Avery failed to plead any facts establishing this, either because he alleged no facts about when this conversation took place, who said it, and why, when, or from where they believed the RAV4 had been driven onto Avery's property. An unidentified DOJ employee purportedly saying they believed the RAV was driven onto the property at some unidentified time fails to establish that it was driven onto the property after the murder or by someone other than Avery. Avery has made no attempt to appeal to show his motion was sufficiently pled on his claim, either as a standalone claim or or on his allegation that post-convictional counsel were ineffective, and simply re-argues the Brady claim. But again, the merits of the claim are not before the court. The issue is whether Avery sufficiently pled the Hallicum, Palin, and Askins were ineffective for failing to raise it. By failing to address the issue on appeal, Avery has failed to meet his burden. Similarly, Avery claimed that the flyover video was edited but utterly devoid of facts and relied wholly on Avery's speculation that the whole footage must have existed because the prosecutor said the RAV was not visible on the video and the flyover produced only 3 minutes of footage. And Avery has again failed to show that his motion has sufficiently pled either as a claim against the post-conviction counsel or as a Brady claim, and simply re-argued the Brady claim, but still provided nothing more than his unsupported speculation that the video was edited. He then asks this court to authorize an impersonable fishing expedition, stating that an evidentiary hearing is necessary to determine the credibility of the state's claim that only 3 minutes of flyover existed. An evidentiary hearing is a forum to prove factual supportive claims, not fishing expedition to discover them. Bullet, which is another statute. Post-conviction counsels were not ineffective in failing to raise a claim based on nothing. Avery's Brady claim about the message the victim left on Zipper's answering machine was insufficiently pled too, because Avery failed to establish that the message was suppressed, exculpatory, or material. Avery did not provide anything from Strain or Buting showing this was not turned over to them or turned over to the defense, and simply declared that it wasn't because the state can't locate it now. That shows nothing. Avery then mused that the 2:15 p.m. voicemail Teresa Halbach left on Zipper's answering machine about having trouble finding their house must have been exculpatory because the prosecution failed to play it for the jury. That is nothing more than speculation. Besides, Joellen Zipperer testified at court and said that Teresa Halbach was at their house around 3 p.m. and that Joellen heard the message later that that evening, but had missed the call because she was outside. Nothing about Halbach leaving the voicemail at 12:12 p.m. stating that she can't find the Zipperer's house, but then later arriving does anything to contradict the timeline established by the state. And Avery still provides only speculation about the claim. He again just says the voicemail may have contradicted the timeline established by the state, that Miss Halbach's last stop was Avery's. He fails to explain how, though. The claim was and is insufficiently pled. Avery's claims about the ineffective assistance of trial counsel were insufficiently pled and conclusively refuted by the record. That leaves Avery's claim that the Halligan, Plain, and Askins were ineffective after failing to claim Strain and Buting were ineffective for failing to pursue and present the retooled planted evidence defense he created in his June 2017 motion, alleging that the quote unquote killer planted the blood evidence and the victim's remains and effects, and relying on a multitude of experts to conduct experiments about the trial evidence. In a nutshell, Avery argued that in his June 17th motion that Strain and Buting were ineffective because Avery believes that he could have prevailed at trial if Strain and Buting had presented his planted evidence defense in a manner current post-conviction counsel formulated. Therefore, he concluded Halligopian and Askins must have been ineffective for failing to allege that Strand and Buting were ineffective on that ground. That is a fundamental misunderstanding of what is required to show ineffective assistance of counsel, trial, or post-conviction. Avery simply alleged that Strain and Buting could have presented the planted evidence defense differently by hiring experts, performing experiments of dubious reliability, and claiming that the blood evidence was planted by the killer and not law enforcement does not provide anything that would establish Strain and Buting were ineffective, even if the facts Avery alleged were true. The accused cannot follow one course of strategy at the time of trial, and if it turns out to be unsatisfactory, claim he should be discharged or have a new trial. To permit a post-conviction counsel to argue for a different game plan after the contest is over would be Monday morning quarterbacking. After all, there are countless ways to provide effective assistance in any given case. Strickland, U.S. 89, and counsel is entitled to formulate a strategy that was reasonable at the time and to balance limited resources in accord with effective trial tactics and strategies. Harrington versus Richter. Neither a disappointed defendant nor a court may second guess counsel's performance solely based on the defense proved unsuccessful. I need someone to take over for a minute. My contact is messing up on me here. Jamie?
Okay, sorry. I didn't know if Millbilly was going to jump in.
We'll give him a rest.
Okay, so second guessing supported speculation is all Avery provided, though either in his motion or his brief, 603. What the heck happened there? Millbilly, you got something in my way. Nope. Okay, there we go. So Avery has simply taken the trial record and working backwards. Stressed what current post-conviction counsel would have done differently had she conducted the defense at the time of the trial. Weatherall v. State. But it has long been settled that it is considered judgment of trial counsel that makes the selection among available defenses, not the retroactive conclusion of post-conviction counsel. Weatherall 73, Wisconsin. And that a court must not evaluate counsel's performance based on hindsight like Avery has done here. Strickland, another case. So rather to show deficient performance, a defendant must show that a counsel's acts or omissions were objectively unreasonable from a counsel's perspective at the time. That is, counsel's decisions were outside the boundaries of reasonable professional judgment under the circumstances. Avery had to show that from Strang and Buting's perspective before trial and balancing limited resources, it was objectively unreasonable for Strang and Buting not to consult and present this bevy of experts and experiments, not to construct this alternate theory of events alleging Ryan Hillegas abducted and killed the victim and then planted the RAV4. The blood evidence and the victim's remains and personal effects to frame Avery and Avery's kitchen sink approach to the issues on appeal has left the state unable to discern what defense he actually alleging Strang and Buting were ineffective for failing to present. Howard v. Gramley. What Avery did not present to the defense instead of the one they chose, Richter 562 U.S., he also had to show their don't move. You got to back up, Billy. All right, I'll skip it. And despite Avery's laundry list of Strang and Buting's alleged failures, Avery alleged no material facts of record that would establish that Strickland required them to do any of this or that Avery was prejudiced by these alleged failures. His ineffective assistance of trial counsel claims were insufficiently pled, so his ineffective assistance of post-conviction counsel claim was as well. State v. Zbart. To establish that post-conviction or appellate counsel was ineffective, a defendant bears the burden of proving the trial counsel's performance was deficient and prejudicial as well. So the response here, several of Avery's claims about trial counsel are misframed, inappropriately raised, or not argued in his brief. Several of Avery's claims in his brief on this point do not warrant discussion because they are misframed, insufficiently developed, or forfeited by his failures to raise them in trial court. Avery's single sentence that he described in his June 2017 motion, a variety of failures of trial defense counsel to conduct a significant investigation before trial, is devoid of any facts or argument that the circuit court erroneously claimed in his June 2017 motion, was that Ryan Hillegas was the only person who could have committed the crime and that Strang and Buting were ineffective for failing to present this theory. As that is what presented to the circuit court when it denied this motion, that is what the state will discuss here. Whether Avery's later motions alleging the other theories were properly denied will be discussed in later sections. You taking over, Billy?
Exercise discretion of even explanation with failures he is discussing. Similarly, Avery never mentions hiring a police procedure or forensic pathology expert as appellate brief until the summary sentence of this point. Though he references experts in these subjects, here in his brief, he provides no developed argument about why Strang and Buting are ineffective for failing to hire them. No Wisconsin case has ever found the police procedure expert admissible. Given the high likelihood of such testimony developing into a mini trial about the procedure and protocols of the police departments, a police procedure expert would be excluded under Wisconsin Statute 90403 for causing confusion of the issues, undue delay, waste of time. It is insufficient to just state an issue on appeal without providing support for the position and providing legal authority supporting the position and the issues raised in the trial court but not argued on appeal and deemed abandoned. A.O. Smith Court versus Allstate Insurance. Avery's conclusory allegations on these claims are insufficient to warrant consideration. Indeed, they are insufficient to even allow the state to formulate a response. State versus Pettit, Washoe County versus Gratt. Avery did not provide any argument on these points, and the state is not required to develop them for him in order to refute them. These claims are abandoned. Furthermore, it is fundamental appellate precept that the court will not blindside trial courts with reversals based on theories which do not originate in their forum. Accordingly, arguments that are raised for the first time on appeal by an appellate are deemed forfeited. In Commitment of Boiling versus the state, several of Avery's appellate arguments about these experts are forfeited. In Avery's June 2017 motion, he claimed that Dr. Christopher Pelnick's examination of the bullet fragment, item FL, and ballistics expert Lucien Hagg's conclusions about item FL were newly discovered evidence. Avery never alleged that Strain and Buting were ineffective for failing to hire Hang or failing to have Pelnick conduct a trace evidence examination, item FL, as now claims. Avery claims that he hired an audio expert, also appeared nowhere in this motion to trial court and is insufficiently developed to warrant discussion. In Avery's motion, he simply declared what the audio clip supposedly said in a single sentence. Avery failed to even identify who this supposed audio expert is or what enhancement they allegedly did, let alone argue anything related to sufficiency of the motion to prongs of Strickland on this point. Avery cannot show that the circuit court earnestly exercised its discretion by presenting arguments on appeal that he did not present on the circuit court. These claims are forfeited. Issues not raised in trial court will not be considered for first time on appeal. Wisconsin Supreme Court versus State and Indiana discussed the difference between waiver and forfeiture and recognized that the rule is more consistent with the concept of forfeiture than waiver. Later in Avery's trial brief, he claims that Strain and Buting could have tried forensic pathologist Dr. Larry Blum to obtain the scratches on Bobby Dassey's back are inconsistent with dog's paws, but the claim was never raised in the circuit court, and certainly not in Avery's June 2017 motion. Avery simply offered Blum's opinion in his July 6, 2008 motion. Even if there were construed in an ineffective assistance claim, the circuit court denied Avery's ineffective assistance claim raised up in the motion insufficiently pled, which is supported by the record. Avery's ineffective assistance claim in the motion was a final catch-all paragraph stating that if the court rejected his Brady claims, it should find counsel ineffective, without developing any argument on that issue. There is no question the circuit court properly denied the allegation without a hearing. Additionally, all of Avery's claims that Strain and Buting were ineffective for their failure to investigate and impeach Bobby Dassey were not for reconsideration. The circuit court denied the claims in Avery's motion for reconsideration and procedurally barred because Avery did not offer a sufficient reason for failing to raise these arguments in his June 2017 motion. Avery has inappropriately re-argued those claims here in an effort to overlap the procedural bar without making any argument. He showed a sufficient reason for failing to raise the claims in his June 2017 motion. Avery. The court will address whether Avery's motion for reconsideration was sufficiently pled in Section 3 of this brief. Avery's remaining ineffective assistance of counsel claims did not warrant a hearing. The ineffective assistance claims Avery both actually raised in his June 2017 motion and has provided some argument about the appellate brief did not warrant a hearing. Avery claims Strang and Booney were ineffective for failing to hire blood splatter expert Stuart James, trace evidence expert Christopher Palahniuk, and to determine whether the RAV4 key found on Avery's house was a sub-key, the DNA expert Carl Reich to test how much DNA a person leaves on a hood latch by touch, and forensic anthropologist Steve Symes. He further claims Strang and Booney were ineffective for failing to conduct various experiments themselves. To discover that Avery's blood in the RAV4 did not come from the vial of his blood located in the Manitowoc County Clerk's Circuit Court office, failing to investigate Avery's claim that his bleeding finger was removed from the sink by the real killer, who then planted the blood evidence in the RAV4, and failing to establish Ryan Hilligus as a Denny suspect. Avery did not provide sufficient material facts in this motion that would show counsels were ineffective for failing to do any of these things. Counsels were not ineffective for failing to hire more experts or perform experiments. Strickland does not enact Newton's third law for the preservation of evidence recording for every prosecution. Avery claimed Palahniuk's rigged other tests were newly discovered evidence, which is addressed in Section 1B. Or IB. Expert on equal opposition, expert from the defense. In many instances, examination will be sufficient to expose defects in the expert's presentation. When defense counsel does not have a solid case, the best strategy can be to say that there is too much doubt about the state's theory for a jury to convict. And here, Avery did not show that. Strickland required Strang and Booney to call these experts or perform these experiments, or that there was reasonable probability of a different result if they had. Cross-examination and the experts they did call effectively established Avery's defense, and Avery's new experiments proved nothing. As a preliminary matter, unlike Avery's other ineffective assistance claims, the Circuit Court addressed that the merits of Avery's claims, Strang and Booney, were ineffective for failing to present Reich's experiments about the quantity of DNA left on the hood latch. Palahniuk's conclusions about the key being the sub-key, the Circuit Court discussed them in portion in order, concluding there was not a reasonable probability of a different result in the trial if Avery's DNA testing related experiments were admitted. To avoid duplication and clearly address the reasons the court gave for denying Avery's motion. That leaves Avery's claims that Strang and Booney were ineffective for failing to hire blood splatter expert Stuart James, forensic anthropologist Steve Symes, and for failing to conduct various experiments themselves. First, Avery had again failed to argue an appeal that his motion was sufficiently pled to warrant a hearing on these claims and merely re-argues their merits. Because Avery has failed to address the issue on appeal, he has failed to meet his burden. Nevertheless, nothing he alleged in his motion met the pleading standard anyway, either because Avery's allegations were conclusory or because the record conclusively demonstrated that he was due no relief, or both. Avery's blood splatter expert James Farr demonstrated that Mr. Avery's blood was planted in Miss Halbach's RAV4. For this proposition, Avery relied on an expert conducted by James, in which blood was dripped from James' middle finger, and he left blood in the test RAV4 in several more places than Avery blood was found. Miss Halbach's RAV4. Avery then concluded that he proved that the blood in Miss Halbach's RAV4 was planted by being selectively dripped and applied with an applicator, because James was able to construct similar blood stains to those in Miss Halbach's RAV4 by that method. Avery further asserted that he provided that the blood flakes found in Miss Halbach's RAV4 were scraped off the Avery sink and planted because when James dripped blood on the floor of the RAV4, it soaked into the carpet, and James was able to create blood flakes by scraping dry blood off the sink with a scalpel. None of that proves anything. I disagree. James being able to recreate something by particular method doesn't show no other method was possible. And James never opines that the most likely source of the blood in the RAV4 was blood in Avery's sink, as Avery claims. James' affidavit says only that the blood in the RAV4 is consistent with explanation other than Avery's being in the RAV4 with the actively bleeding finger, and that James would expect the actively bleeding finger to leave blood in other places. Simply assume a number of variables James cannot account for, such as how deep Avery's reopened cut was, how much a particularly healed cut would have bled, and how he moved the RAV4. And the many other ways blood flakes could end up somewhere. James' next experiment, purportedly providing that the blood splatter on the rear cargo door was caused by Miss Hallbox being struck with an object such as a hammer, with the cargo door open rather than being thrown into the cargo area, irrelevant even if true. The point was that Miss Hallbox's blood was in the cargo area, showing that she was at some point bleeding there, not the exact method of how the blood got there. And nothing in Avery's motion of the exhibit cited supports his conclusion that the bloodstains occurred. The result is a conclusion that the bloodstains occurred as a result of the RAV4 being driven anywhere. But again, the question here isn't whether Strang and Booting have presented James' experiments, the opinions the experiments could show. The question is whether Avery sufficiently pled that it was objectively unreasonable for them not to do so, and that it was prejudiced. An explanation why even an allegation that was unreasonable for them to not do so is absent from Avery's motion. Nor did Avery explain how he could possibly be produced by this attorney's failure to hire an expert. That did not rule out anything relevant about the state's case. And Avery has failed to argue and appeal that the motion was sufficient and even that it was objectively unreasonable for Strang and Booting not to hire James. He again merely attacks the evidence submitted by trial. Avery claims in the brief that these experiments were conducted within 1 to 2 millimeters of blood. James' affidavit never says that either. Whether current post-conviction counsel can attack the trial evidence does not issue an appeal. Avery makes much of Strang's affidavit, stating that he should have hired a blood splatter, ballistics, or trace evidence expert, but what Strang thinks now is irrelevant. After an adverse verdict in the trial, even the most experienced counsels may find it difficult to resist asking whether a different strategy might have been better. And of course, that reflection to magnify their own reasonability, for an unfavorable outcome. However, calls for an inquiry into the objective reasonableness of counsel's performance, not counsel's subjective state of mind. And at any rate, Avery did not provide the affidavit to circuit court until his motion for reconsideration. Therefore, it has no bearing on whether the circuit court properly denied his claims raised in his Avery's 2017 June motion. Avery's claim that Strang and Booting were ineffective for failing to hire Seams is particularly insufficient. They did hire and present a forensic anthropologist who specialized in burn remains, Dr. Scott Fairgrave. So Avery's claim really is that they were ineffective for failing to hire this particular expert. But an attorney is not deficient for hiring one qualified expert over another. Ineffective assistance does not consist of the hiring of an expert who, though qualified, was not qualified enough. The selection of expert witness is a permanent example of the type of strategic choice that, when made after a thorough investigation of the law and facts and virtually unchallengeable, citation omitted. Neither Avery's motion nor his brief says anything about why Strang and Booting perspective. Before trial, it was unreasonable for them to rely on Fairgrave, who had testified for the prosecution in every case in his career until this one, and who refuted the state's forensic anthropologist, Dr. Leslie Eisenberg's conclusions. Avery gave no evaluation to Fairgrave's trial testimony, nor discussed why Sims could accomplish something that Fairgrave's testimony, coupled with cross-examining Eisenberg, did not. Nor did Avery provide any explanation why it would matter if the charred bones found in the Manitowoc gravel pit were determined definitively to be human, which is all he claims. Sims' revelation could have been. Though Avery did not even establish Symes, what would have said this? Symes' affidavit says only that he believes a microscopic examination could have determined whether the bones in the gravel pit were human. Though it gives no explanation why Symes believed he would accomplish this through a microscopic examination when the FBI could not. It's entirely possible Symes would have been able to do so, or would have determined the bones were not human. So Avery, again, simply relies on unfounded speculation that Symes would have been able to establish anything relevant. Avery claims that Symes determined that the bones in the Manitowoc pit were human. The state's entire theory against Mr. Avery would collapse, but that is simply false. Some of the bones in the Manitowoc County gravel pit were possibly human. Miss Halbach's remains were already found in multiple places, meaning that they were obviously moved, which both Eisenberg and Fairgrave testified to. Avery failed to explain why, if the bones in the pit were human and Miss Halbach's, he or his accomplice, Bernadassi, could not have put them there. And Fairgrave testified that, in professional opinion, Miss Halbach's remains have been removed to Avery's burn pit and was not a primary burn site. Adding one more location, Miss Halbach's remains, to be found does not shake the state's case against Avery at all. Finally, Avery's speculative leap that if any of Miss Halbach's remains were found in the Manitowoc County gravel pit, then she must have been murdered there and supported neither by Symes' affidavit nor anything else. Symes would have added nothing. Not only did Avery insufficiently plead his claim that the Strang and Booney were ineffective for failing to have someone stand in the vicinity of Mr. Avery's burn barrel while it was burning and see if they smelled any plastic, but the claim is also frivolously in the context of the case. The evidence that Avery burned Miss Halbach devised in the burn barrel was far from supported only by Fabian's testimony that he smelled burning plastic, and as Avery claimed, it was also supported by the burn remains of those things found in Avery's burn barrel, and the testimony blamed Dassey that he saw Avery toss a plastic bag in the actively burning burn barrel. Further, Avery's experiment could not account for the environmental conditions on October 31st, 2005, and sensitives to Mr. Fabian's, or the fact that Avery clearly put out other items in the barrel as well. More importantly, Avery again did not provide any argument to the trial counsel where objectively unreasonable for failing to conduct the experiment, or that there was reasonable probability of different results if they had. Avery's argument on the point appeal consists of the single sentence stating he conducted a series of experiments refuting Mr. Fabian's trial testimony, and on October 31st, he was in the vicinity of Mr. Avery's burn barrel and smelled burning plastic. That does not establish anything about Avery's motion or either prong of Strickland. Avery's claim that Strang and Booney were ineffective for failing to conduct the experiment. In a similar bookcase in Avery's bookcase, Miss Halbach's Toyota key fell out from the back when Sergeant Colburn jammed material back into it even further afield. First, Avery did not conduct an experiment with the bookcase and the Toyota key. Avery conducted his experiment with a substitute bookcase, which as video shows was in a better condition than Avery's actual bookcase, and an experiment key. Importantly, the experiment key and lanyard were able to be pushed through the back of the experimental bookcase by striking it with the photo album. Further, Avery admitted that Booney argued that it was impossible for Miss Halbach's key to have landed in the position it had fallen out the back of the bookcase. That was improbable. The key would do so. Booney's arguing this without providing the jury with Avery's new bookcase experiment, definitively proving that state's theory that the key was pushed out the back of the bookcase and was possible was neither deficient nor prejudicial. The claim, too, was officially pled. Avery did not say who, how, or why someone would have knowledge, and there's a footnote. Tools necessary to collect and transport his blood from his sink to create bloodstains found in Teresa Hallbach's RAV4, or how they could have accomplished this while leaving no trace of themselves. Avery's blood splatter expert James used pipettes and applicator to create similar bloodstains in the test RAV4, which Avery claims proves that the killer planted Avery's blood in this manner. Why anyone would just happen to have pipettes and applicator on hand while trying to plant the RAV4 defies explanation, and Avery offered none. It also utterly unsupported the fact of the record, nor did Avery explain how someone would have kept his blood liquid long enough to plant the droplets, or why someone would come back half an hour later, this time apparently scalpel, and collect dry blood flakes from his sink. And Avery did not explain how a person would have successfully transported those to the victim's RAV4 either. Moreover, the only way to portion the property where Avery's trailer on required a person to drive west past bar beyond his trailer to business buildings there, because there was a 20-foot berm. They're lying. There was a road that went in between Cuss Road and his property, right around the cornfield. They're even lying now. Trailer from the cross-section to salvage yard and veranda pit. Avery claims he and his brother Chuck saw taillights near Avery's trailer while the two were leaving Avery property. They turned around and investigated, in which time someone purportedly drove a RAV4 back to Cuss Road. But to get anywhere near Cuss Road, the person would have to go directly towards Avery Chuck's before turning south. They're lying. You guys are reading this, right? RAV4 and trailer next to twice in this scenario. Avery particularly failed to explain how Ryan Hilgis, Ms. Hallbach's former girlfriend and longtime friend, could have accomplished any of these things. He was allowed on the property damn near every day. No questions asked. Twice on the 7th. Then they start finding everything. Coincidence? I think not. How or why Hilgis would have any familiarity with the Avery property or surrounding? He had maps he was handing out to everybody. He knows the property. Such bullshit. Get back to this, though. Hilgis sat for days undetected, the RAV4 waiting to see Avery leave the property. When Hilgis could have planted the blood evidence in the RAV4 and the RAV4 itself and multiple people. Hilgis all night on November 3rd, all day, late into the night of November 4th. Who this alleged accomplice was, who Avery claimed helped Hilgis leave the property, or that one even existed. How or when Hilgis could have transported and disposed of the victim's remains, Ineffective when noticing. How he would have gotten Miss Hallbach's DNA onto the bullet that fell, and placed it in Avery's garage. How anyone could have driven Miss Hallbach's RAV4 onto the property near Avery's trailer, where Hilgis supposedly hid Miss Hallbach's RAV4 between October 31st and November 4th, precluded it from being found. Additionally, and perhaps more importantly, Avery provided not one shred of evidence from the record to establish that any of the facts he alleged of this theory existed, other than his own self-serving affidavit and rank speculation. Nearly all his alleged facts, unsupported by any record citation, and a few things Avery does cite do not establish what it concludes. For example, Avery provides nothing showing Miss Hallbach RAV4 collided with the post on Cuss Road, but he simply provided a picture of the post and concludes that because the RAV4 in its direction of light was knocked out, the killer collided with this post while attempting to plant the RAV4. The existence of the post is the fact that the supporters Avery's conclusion that Miss Hallbach's RAV4 collided with it, let alone the killer did not while trying to plant the RAV4 on Avery's property. The search remains mere speculation and insufficient to support guaranteeing a hearing. After reading this, they're denying every single motion she has. Counsel and effective fans. So this is going to go to the higher courts. It depends on what the Court of Appeals decides. Hopefully they do the right thing and they grant the evidentiary hearing at least. Nor would Avery's non-existent facts enough to prevail in any motion alleging Ryan Hilgis was possible third-party suspect. Nothing alleged in this motion established jealousy as a motive. It was like the rest of the Avery's allegations unsupported by the record and spun entirely from conjecture. After providing nothing establishing that the abusive relationship between Halbach supposedly was in with Hilligus, Hilligus knew about Halbach's sexual history of Blodorn. Even if Hilligus did not know about it, he cared. Avery just proclaimed with no evidence whatsoever that Hilligus committed perjury about it, nor did Avery point to anything suggesting an attempt. Well, I got audio that proves that on the morning of the 7th, Scott Blodorn is being talked about by Mark Wiegert because they just found out that apparently Teresa Halbach and Scott Blodorn had a sexual relationship. We don't have any reports of them talking to any of these people. And he also states in that call, we have yet to talk to him yet. But then he shows up on the property 2 hours later, leaves, comes back about 4 o'clock the same day, along company with Ryan Hilligus. The Hilligus knew about Halbach's sexual history before Blodorn perjury about it, nor did Avery point out anything suggesting or attempting to explain why. After 4 years of uneventful platonic friendship, when the Hilligus saw Halbach at least once a week, Hilligus suddenly became jealous about Halbach seeing other men, and not just jealous, but out of blue, Hilligus became enraged and committed murder. Further, Avery did not provide anything directly connecting Hilligus to the crime. Avery could not have prevailed on any motion alleging Hilligus was the killer because of all the alleged facts and pure speculation in counsel. All right, I'm going to stop this right here, and we're going to continue this on a different day because there's still a whole lot of pages to go. But I'd like to get your guys' thoughts on what we've read through so far.
I'm confused. I won't lie. Like, I don't know any legal aspect. So I'm listening to it. All it sounds like to me is they're copying and pasting the same paragraphs and changing a few words around. There's a lot of repetitive shit.
Yeah, I agree.
But on a legal aspect, I will be honest, I have no idea. I think I've died twice listening to this. I'm
They're
not sure.
They're denying his motion for post-conviction relief. It's going to go back to the Court of Appeal. They're going to make their decision, and if I think what's going to happen, they're probably going to side with the state, and Zellner's going to have to take it to higher courts.
Yeah, I sort of saw that coming anyway. I'm not surprised. Are you?
No, not at all.
Yeah, me either.
Well, and we know Kathleen isn't surprised either. She has said from day one this could take up to 15 years. She's seen it in the past.
Well, look at all the other cases she's won. It took at least 10 years or more.
And I just want to thank Travis. He's been here throughout this, and he's been answering a lot of people's questions. So thanks, Travis, for that as well.
Thank you.
He has stated a few times, he said that he's, I asked him straight out, was he worried, like concerned? And he said, yeah, he has been concerned regarding the last one the last motion she filed and then withdrew and then did another one. Again, I got what he was saying, but I don't, on the legal aspect, understand the whole concept of it. So thank you, Travis, though, for answering all the questions while we were on. Yeah.
Well, and Travis knows.
I don't care about my subscribers. I don't care about none of that. I don't care.
He doesn't mean that in a bad way. He means
Just
that
for the record, I don't care about none of that.
He's not saying he doesn't care about you as a people, just numbers. It's not a thing.
Don't mean nothing. All I care about is the truth and exposing all these lies.
That's what we're here for.
I mean, you just go through all the search warrants. They lie at every chance they get.
I kind of find it sad that we're supposed to be a country that, you get every chance to, state your case and everything. And the
state's protecting the Halbach family.
Yeah, I definitely see that. But I also feel they're doing everything to protect themselves. It's like everything that they brought up, they have a reason why it should not even be considered. and they're deflecting, totally deflecting.
Well, we got through 54 of the 130 pages. I don't really need to read them. I already know what they're going to do, but.
And what's sad is because, here we had, before any of this started going on, we had Fallon agreeing to do a few things, and they're like totally disregarding that altogether.
Are you guys all hiding behind your icons? Show the people who you are.
I've been on lives before on camera, but I got wind-blown hair, so no.
I took my contacts out, so I'm a hot mess.
There you go, Mel Billy.
Thank you, Justin. So
maybe if I put on a hat, I'd be all right with it.
there's a lot of info, but it's just they're striking down everything Zelma brought up. I'm not surprised at all.
No, guess what? We're all used to disappointment in this case. But think about it. I mean, if you look at this from 2015 when it came out, we're only 5 years really from the documentary, but probably anywhere from 3 to 2 years for a lot of the people that started researching it, 3.5 maybe. So I mean, we're still in the early stages of it.
Yep. Well, it's very telling on the stuff they won't release. They got nothing to hide.
Well, the only problem is if you think about this, I mean, the state is using the taxpayers' money against their own people, really. I mean, if you think about it, they're using their power and their money, which is provided by the people, against their own people. They're just like I said in the chat earlier. They try to say that ignorance is no excuse for ignorance is no excuse for the law or understanding the law, but yet they make the wording such a joke and they skirt around everything that they can, specifically to screw the people. The legal system is not about the people whatsoever. It's about our government.
Yeah, I agree with that totally. So let me know if I'm understanding right. Basically what they're saying is they should not have been allowed to remove the, basically go ahead and make another motion while they had one that was still being reviewed without getting approval from the state to do that. Is that what you guys are understanding too? That's part of their argument is, all right, they already had something in front of them. They shouldn't have been able to put another one in or add any additional information other than what they did in the first one without getting approval from the court to do so.
I'm going to put the link to the document in the description of the video if this is over, but I don't know if you're able to click on that in the chat, but if you are.
Travis has got a question, Millbilly. What was the lie that you were reading? Was it on RH or before that?
Oh, on Ryan Hilgis. And the fact that he didn't know about Scott Bloodhorn and sleep. They lie all the time. Morning of the 7th. You hear Wiegert saying, oh, we just found out apparently Scott and Teresa had a sexual relationship. We have yet to talk to him about that. 2 hours later, Ryan Hilgis and Scott Bloodhorn are showing up together. That's why when they're asking Mike and Ryan if they've ever been on the property before, Mike doesn't know what the fuck they're talking about, but Ryan does.
Yep.
So, Travis, were you saying yes, that my understanding was correct? Because that's what I'm trying to figure out. But that's pretty much in a nutshell what I was getting from it.
Yep.
Okay. Thank you.
Thank you, everybody, for tuning in. Continue the rest of this probably on Sunday. Don't know what time yet. But I am working on some other things. Just got to get it done. So, y'all have a great evening.
Thanks
Thank
for
you.
listening.